Welcome to the People's Law School. This is being brought to you by the McCracken County Bar Association and TV channel Paducah 2. We are here this afternoon to talk about Kentucky workers' compensation law. And with me today to help cover this area of the law is Dan Stratemeyer. Dan is a lawyer with Saladino, Oaks, and Schaff. He graduated from the University of Illinois School of Law in 1992. He practiced for over 11 years with a firm representing the defense, which is employers and insurance carriers. And then for the past 4.5 years, he's been associated with the Saladino, Oaks, and Schaff law firm representing injured workers. I'm Craig Housman. I graduated from Vanderbilt Law School in 1973, and throughout the intervening years, I have been representing injured workers in this area. Dan, if somebody gets hurt at work, what's the first thing they should do?
Tell your employer. That's the first thing you should do. I guess depending on the seriousness of the injury, maybe medical attention might be the first thing. But as far as making sure that your claim gets properly going, you need to let your employer know what happened, how it happened, and the sooner the better. Now in Kentucky, there is no set time deadlines. You're not required to do it within a specific number of hours or even days. It's a reasonable requirement here in Kentucky, but always the sooner the better, and the longer you wait to tell your employer, the more problems it may cause in the long run.
Actually, under Kentucky law, it is a legal requirement. In other words, if the employee keeps it a secret for months and months with no good reason, even an otherwise valid claim is gone out the window.
That is exactly right. Prompt and reasonable notice. I think the actual words in the statute is due and timely notice under the statute. If you don't give your employer, again, prompt notice of the injury, you are really jeopardizing your entire claim, and that's the first thing that should be done, not only for the reason of protecting your claim, but it also lets the employer know if they need to take any special measures to protect you from working the remainder of the day or take you to the hospital. So there's many reasons, both legal and medical, to tell your employer immediately when you've been injured.
Okay. If the employer has lectured its employees saying, report every injury, and if you don't report it within 24 hours or 72 hours or a week or something like that, then we're not responsible, it's not covered. Is that the law in Kentucky?
No, that's a great question, because many employers have handbooks, and of course in the handbooks they always say that if you're injured on the job, you have to give notice of, they vary anywhere from immediately to up to 24 hours or within 48 hours. And I've had a lot of people call me and say, well, the employer said I was supposed to tell him within 24 hours and I didn't do that. And they're saying I can't pursue a workers' compensation claim. And that's just not true in this state. Again, there is no deadlines for giving notice. Even if your employer has an internal policy, that does not trump or outweigh the statutory requirements of the Workers' Compensation Act, which is only due and timely notice, which is more of a subjective measure. Now, it is always helpful that if your employer has a policy, that you try to obviously comply with the policy, because they might use that against you if there's any litigation to say, well, we have this policy, the reasonableness should be in compliance with our policy. So if there is a policy, do everything that you can to comply with it, but even if you don't, that does not mean that your claim is automatically gone in this state.
Okay. I know as a practical matter, from having talked with so many people through the years, that most employers, really do not like to get reports of injuries, and they frown on it. And you've got all these quote safety unquote programs where they promise all your fellow employees a reward if there's no reports of injuries, and so there's a great deal of pressure put on most employees, on one hand to report it, and on the other hand not to report it. So
That's exactly right. In some of your larger plans, they have incentives or bonus programs for no loss days for a month, or for ever how long you can go. If you have a no loss time injury work record, there's bonuses given. And oftentimes just the employee, and I find this a lot to be with the callers that I have, they don't want to cause problems. They don't want to cause any waves. They like their employer, they like their job, and boy, they just really don't want to cause any waves at work. And I understand that. I actually appreciate that philosophy. But you never know the extent of your injury when it first happens, and any delays of giving notice and not reporting it, it might work out fine, and you might not ever need to pursue any legal action, but you are certainly jeopardizing yourself if you do not give, again, the proper notice. And for the employer also, I in my past have represented employers and insurance companies, and really more for the employers. Most employers have insurance. And sometimes if they do not report the injury to their insurance company in a timely manner, they're also perhaps jeopardizing their coverage with the insurance company for failing to promptly report not only the injuries to the insurance companies, but you haven't gotten there yet, but to the Department of Workers' Claims as well. And there are state requirements that employers must. It's a statutory requirement that they give notice of any injuries, especially I think work loss injuries of a day or more, have to be reported. And it's not only good for the employee to make sure that all injuries get reported, whether the employer knows it or not, it's really in their best interest as well, because if they don't write it down, if they don't take down what the employee is telling them, then they don't have a record of it as well. So it's really in everyone's best interest that these things get properly reported and put in writing.
one of the things that I think we need to emphasize is, we've talked about claims, and obviously that's how you and I make a living, is helping people with claims and trying to get injured workers what they are honestly due in terms of dollar income benefits. But one of the things that I don't believe most working people appreciate is how, with our fragmented healthcare providing system, how important it is that if you actually got hurt at work, that you report it that way, promptly in order to have medical coverage. Because one of the problems that you run into is if you read if you're one of the lucky folks who's got health insurance that's available through your employer, well, if you get to reading the actual terms and conditions of that health insurance policy, most of them specifically exclude work-related injuries, and that's true whether the work comp insurance company pays it or not.
That's a great point, Craig. A lot of people, again, thinking they just don't want to cause waves at work, they'll say, well, I'm not going to pursue this. I want to just turn it into my health insurance. My health insurance will take care of it. And, I keep my good relationship with the employer. I get my bills paid. Everything is fine with the world. Well, sometimes they find out, they start going to the doctor, the medical bills start coming in, and all of a sudden they get a letter from their health insurance saying, well, you're being treated for a work-related injury. We do not cover work-related injuries under our policy. And then they go and try to report it as a work injury, and then all of a sudden they've waited too long, that they didn't give reasonable notice. And that's a very good point, Craig. You just cannot be certain that there's going to be other sources of payment for your work-related injury. And I think a lot of people think that when they have health insurance or other sources of payment, I'll just turn it into them and I have no worries. That's a great point, Craig.
One of the things that comes up quickly after someone is hurt at work and they need to get medical treatment is the question of who has the right to decide where the injured employee goes for treatment. Is this the employer's choice? Is this the employee's choice?
Generally speaking, of course in the law there's exceptions to every rule, but generally speaking the employee determines who he wants to treat with. Again, just a couple of the exceptions. If the employer is part of what is called a managed health network, and they actually have a list of authorized physicians, the employer can demand that you choose a doctor from within the list of authorized physicians. But again, it's still your choice of which doctor you see within that list. Again, most employers and insurance companies are not part of a managed health network, and therefore they can, again, choose their own doctor. Another limitation that the employer can put on you is even after choosing your own doctor, they can have you designate the physician that treats you. It used to be called a gatekeeper physician. That was to sort of control not only your treatment but who you were referred to. The employer or the insurance company can ask that you designate which doctor you want to be that person so that you're not going from doctor to doctor to doctor. They can sort of limit the one you go to, but you get to choose that one. And you can choose that for whatever reason. You can change that physician as you treat if for some reason that doctor moves out of town or for whatever reason that doctor doesn't feel comfortable treating you any longer, or you don't feel comfortable with that doctor, you can change physicians. But again, for the most part, the first doctor you choose is really up to you.
So if the physician says, I want you to go see the company doctor in Calvert City, or I want you to go see Ocunet or one of these other places that seems to try to get referrals from employers, does the employee have to go?
They do not have to go. Obviously, a lot of employers are somewhat persuasive, and especially if the employee doesn't know their rights, they tend to do what their employer tells them. No, they do not have to go. They can certainly, again, choose the doctor they want to go to, but a lot of people, they don't have their own doctors, and for the most part, they'll do what their employer requests. But no, it's not mandatory that they go.
And that's consistent with what, if I'm consulted, that's quite similar to what I recommend is if they want you to go someplace for an initial exam or something like this where they want to have you drug tested or that sort of thing, or have a physician look at you that the employer picks, don't make waves, go along with that. But before you sign on the dotted line on that Form 113 about what doctor you want to be as your gatekeeper physician, it should not be somebody that the employer picks unless you are in one of these situations where there is an approved health care network,
Correct.
I think is the term in the statute. And I think the point you made, and one I kind of want to reemphasize, is that even if the employer or the employer's health nurse or the insurance carrier's adjuster says we're in a managed health care network and you've got to go where we tell you, the honest answer is if they've got an approved managed health care network, it has to be one that offers the employee choice within the plan.
That is correct.
And so the response is, where's my list of choices?
That is right.
Not you've got to go to Dr. X or you've got to go to Dr. Y. And one of the other things, while we're talking about the choice of gatekeeper physician, is in my experience, it is wise to pick someone who is a general practitioner, a family physician, an internal medicine specialist, a Oh gosh, those would be the two primary, and let them refer you to specialists, because it is misleading, and many of the claims representatives with the insurance carriers want to tell the injured worker, you've got to treat with just this one doctor. You picked him, he's where you stay. Even if your gatekeeper wants to refer you to a different specialist, or perhaps let you try chiropractic care, which they have a right to do. You know, if you pick a generalist, then the statute provides that he is a gatekeeper, and you have a right to be treated by that person and any other specialist that he or she wants to send you to.
That's right, and that's what I was alluding to when I mentioned the referrals. Obviously, many injuries need specialist care. Well, if you think that the general practitioner, as you say, the insurance companies say, well, that's the only person you can treat with, you can't see a specialist. That's not correct. As long as the general practitioner or the gatekeeper refers you to the specialist, you can see whoever they refer you to, and it's still, again, as long as it's traced back to the gatekeeper or designated physician.
If the employee is hurt at work, gives prompt notice, and misses 5 days, the next 5 days of work, has a doctor's excuse to be off work for those 5 days, are they due any money from workers' compensation for income replacement for that first 5 days?
Probably one of the most often asked questions that I get is, I've missed the last 5 days of work, and my employer's not going to pay me. Well, I always have to give them the bad news. They're not required to pay you. Now, again, whether it's 5 business days or 7 days for a full week, however you want to look at it, I guess not everyone works 5 days. But I think what you're referring to is the part of the statute that says if you have to be off work or have an off work excuse for more than 7 days, of course that would be 5 business days, I guess, in the normal normal work week. That first 5 business days or work week, there is no compensation for the injured employee under the Workers' Compensation Act. If you have sick days, you're going to have to use them for those days. If you have vacation days or whatever days you have built up, you have to use those. Now, what's interesting about, will I ever get paid for those if I continue to miss work? If you continue to miss work after the 7th day, and if you actually in fact miss more than 2 weeks of work, in other words, you go up to your 15th day of missed work, which would be 2 business work weeks, then they'll go back and pay you for the first week. So it is sort of an interesting, I would love to have the explanation on how that part of the law came about, why a person gets no compensation if they only miss up to the first 7 days, but that is the law. I can only tell the people who call in what the law is. As far as explaining how it got there, I can't do that, but that is true. I get that question a lot if they've only missed a few days of work.
When we start talking about what income benefits an injured worker is entitled to receive, what sorts of things can an injured worker expect to be paid if he's being treated fairly and paid everything he should receive from the employer's workers' compensation insurance carrier?
First of all, there's going to be compensation for the work you were missing, but the first benefit a person gets is they'll get their medical bills paid. So even if you miss no work whatsoever, but you have to go see a doctor or go to the hospital, the medical bills should be paid as long as it's a work-related, you gave reasonable notice. The medical bills should be paid for the work injury. Now, going to the scenario where the person actually begins missing not only days of work, but weeks of work. Mm-hmm. For each week of work missed, again, for more than 15 days, you are allowed 2/3 of your average weekly wage. So if a person makes $600 per week, and that's gross pay, before taxes or other deduction, if they make $600 a week on average, while they're off work for the work injury, they would get $400 from the employer or the workers' compensation carrier.
Per week.
Per week, that is correct.
Then that continues to what point? How long? I think that's called temporary total disability
That
payment.
that is correct. Obviously, there's legal names for everything.
Yeah.
I refer to it as off-work benefits. When a person is off work, totally off work for the work injury, the legal name is temporary total disability, which means for a temporary period of time, the person's totally disabled. They get 2/3 of an average weekly wage, of their average weekly wage. They will continue to get that payment until such time as they have been released to work. In other words, if they go back to work, obviously they're no longer totally disabled. Their benefits will end. If the doctor releases them to some form of work, they can be cut off. But the usual way it's cut off is when the person reaches maximum medical improvement, which again is a medical term of basically the doctor saying you're as good as you're going to get, and that's when the off work benefits can also end.
One of the places where another doctor comes into the picture is if someone has been receiving temporary total disability benefits for several months and the treating physician continues to think that his or her patient needs to stay off work, but the insurance adjuster thinks that that's too long. Does the insurance carrier have a right to send the worker to a physician of the claims representative's choice?
Yes, the infamous IME, or independent medical examination. Oftentimes, when a person has been off work, candidly for too long in the eyes of the insurance company, they will set up an evaluation for the injured worker to go to. Of course, this is a doctor that the insurance company has chosen, and they have the right. They have that right. Anytime a person is seeking benefits under the Workers' Compensation Act, again, this isn't just a one-sided system. The employer has rights as well, and the employer can send the employee for an independent medical evaluation. And if that doctor, in his or her opinion, believes that the person can do something, there is work available for that worker, or that the injured worker has reached maximum medical improvement, they can cut off the temporary total disability at that time, or the off-work benefit. And then obviously there's a battle between the treating physician keeping you off work and then the independent medical examiner saying you can, and that's when we suddenly go in front of a judge sometimes.
Okay. The checks stop if the adversary medical examiner, that's euphemistically called independent, says they've reached maximum medical improvement. The injured worker's checks stop. That's regardless of whether or not the employer will put them back to work.
That is correct.
Okay.
That is correct. And sometimes the person falls through the crack because they're not getting their work comp benefit, but there's no job to go back to.
So how long does the process take once they get cut off and you have to ask a judge to resolve it?
Basically, once the off-work benefits are terminated or cut off, then the next thing that happens is, obviously, I think, at least in my practice, you always first try to settle the case, try to work it out with the employer or with the insurance company. Oftentimes you can work it out and no litigation is necessary. Oftentimes you cannot work it out, and then you have to file what is called a formal application with the Department of Workers' Claims. Then your case goes in front of a judge, and the judge determines any issues that are in dispute. And that can be a 9-month process.
Okay. That's about my experience as well in terms of the time length on average, and assuming you don't get off docket. But one of the things that I want to be sure that we leave with our listening audience who stayed with us this far is, what if the employee goes back to work? When his doctor or the independent medical examiner says he can go back, the employer puts him back to work. Are there any problems with simply letting it lie, with not seeking any sort of settlement without if the worker does not file any sort of claim, if he just says, well, they've taken care of me, I'm back at work, I'm going to leave this alone, I'm not going to make waves, I'm a loyal employee, my employer will take care of me if I have more problems with my hurt knee or my hurt back or my hurt neck in the future. That good logic?
No, it's not. It sounds like it. Again, there's a lot of people not wanting to cause waves. They're happy with what the employer insurance company has done. So they say, I'm going to just let it go, and hey, they've been good to me now, they'll be good to me in the future. The first thing is, even if you do not want to pursue a disability claim, which is actually compensation that you get. A lot of the people who call in say, I don't want to pursue any compensation or disability, but I want to make sure my medical benefits are secured in the future. Well, you still have to do something. Medical benefits for a work-related injury can be for life if the proper paperwork is filled out and filed in a timely manner.
Is the bottom line that you've either got to file a formal claim or reach a formal settlement within 2 years of the date of injury or 2 years of the last one of those temporary total payments, or it's over with?
That is correct. All medical benefits, disability compensation is out the door at that point.
And if the employee does not protect his right to future medical by filing a formal claim or reaching a formal settlement, is he then stuck back in the same problem if he has health insurance or gets health insurance or has Medicare or Medicaid or something like that? If he has some alternative source of paying it, is he then stuck with the same problem of, if work comp is supposed to have paid it, will the health insurance carrier or Medicare or Medicaid?
That's exactly right. That goes back to, I think, the very first thing we discussed before when we started. You better pursue your rights under the Workers' Compensation Act, because there's no guarantee that a health insurance company, Medicare, or any third parties going to pay any of your medical bills in the future. So get it done within the 2 years.
And it's been my experience that even employers who want to take care of their employees, they still don't have the right to tell their own insurance company what to pay and what not to pay. And so it's terribly important that if in fact you've been hurt at work, that you take the proper steps to protect your rights, because if you don't, no one will.
That's right.
I'm afraid we're about out of time, and I have very much appreciated the attention of the folks who have watched us, and on behalf of the McCracken County Bar Association and Paducah 2 TV, we'd like to thank the audience once again.
Thank you, Craig.